Okay, when Platinex sued KI, it engaged the power of the formal legal system. And this is what crystallized the conflict between the three legal systems that converged on KI territory. Within dominant Canadian culture, law is seen as an institution that's mostly separate from everyday life. Okay? It's only called into action to deal with a crime or to resolve a dispute. Specific individualized conflict is partly what makes law visible in our society. Once law is made visible through a conflict, it's assumed that law will deal with these kind of conflicts in some kind of fair and objective way. So there's kind of a tendency to separate law from everydayness, right? There's a separate institution, judges, there are people trained specially to work in law. Okay? Now, John Borrows argues that because these roots are hidden, that tendency to separate law is one of the ways that law hides its social and cultural roots. Okay, so we see it as neutral and objective. We don't see it as reflecting cultural norms of the dominant society. Because these roots are hidden by this separation, then, law is understood as objective, and it's difficult to see the biases. First Nations law is even less visible in Canadian society. It is similarly revealed when it comes into some kind of conflict or when there is a conflict with the larger society. Several Indigenous legal scholars have argued that Indigenous law needs to be respected in order for reconciliation between Aboriginal peoples' occupation of the land and the Canadian assertion of sovereignty in order for that reconciliation to come to fruition. So the argument is that Aboriginal rights and treaty rights in Canadian law arise from traditional laws and traditions, okay? Because it is those laws and traditions which express and embody Indigenous peoples' relationships to the land, okay? And so those laws need to inform the construction of Aboriginal treaty rights in Canada. Failing to see and respect Indigenous traditional laws then becomes an obstacle to a fuller understanding of those rights and an obstacle to reconciliation, okay? Now, there are many potentially useful guides for non-Aboriginal and Aboriginal communities living together that can be found in Canadian law. One of these is the concept of Aboriginal law as sui generis, or unique, okay? As well as Section 35's promise of recognition and affirmation of Aboriginal rights. Now, these are broad concepts that can be used to deal with building new relationships and can contribute towards a more respectful way of working together than in the past. One of the problems is that these concepts tend to be interpreted through struggles that end up framed in the narrow confines of private law, okay? And for example, in the suit of Platinex against KI, it's framed in terms of economic damages and ideas of contempt of court. So that means that the guiding principles of Section 35 can't really be discussed in a broad, fruitful kind of way, but rather get framed in these very technical approaches in law. Okay, so that limits Section 35 when it's brought forward through these kind of conflicts, which end up funneled into private law. When the community went to the drilling site and protested Platinex's presence, they invoked Kanawandan Ducky. And in taking this action, they were practicing their legal and spiritual duty to protect the land. So that, to me, leads to another question. Okay, so if Section 35 is supposed to provide a new way of considering relationships between Canada and First Nations, a new way of looking at First Nations traditional attachments to the land, then we can ask what happens in law when Canadian law confronts these Aboriginal traditional laws. Okay, so the question is, what spaces are opened for and what spaces are closed against understanding Kanawandan Ducky and community self-determination in the legal decisions? Okay, so now I want to get into the specific decisions. Okay, now the first hearing was in July 2006. And what happened was that the judge granted an injunction in favor of KI. Okay, now this was actually pretty rare. Lower courts had kind of stopped granting injunctions to Aboriginal First Nations in the roughly around the mid-1990s. Partly because they had developed an idea of the public interest that associated the public interest with economic development. Okay, so any economic development was basically in the public interest, and so the balance of convenience then would outweigh any concerns about stopping development while First Nations claims to title or to treaty rights were worked out. So in that the judge went against that trend, this decision received quite a lot of legal and political attention. Now I'll just go back a minute and say the basis for awarding injunctions. When someone claims an injunction against somebody, there's three questions that have to be looked at. The first question is there a serious issue to be tried? Aboriginal treaty rights are serious issues. Okay, so that was one. The second is the risk of irreparable harm. And then the third is the balance of convenience, whether it's on the side of granting the injunction. Irreparable harm is defined as harm that cannot be compensated for with money. Okay? And the public interest is sort of this general idea that can be included when a judge is assessing the balance of convenience. Okay, so the decision here was based on the finding that KI might suffer irreparable harm due to the potential loss of its connection to culturally and spiritually significant land. Justice Smith wrote, "It is critical to consider the nature of the potential loss from an Aboriginal perspective. The land is the very essence of their being. It is their very heart and soul. No amount of money can compensate for its loss. Aboriginal identity, spirituality, laws, traditions, culture, and rights are connected to and arise from this relationship to the land." So what happened here was that KI's perspective on their attachment to the land as the source of their being, their way of life, and their rights was recognized as something that could be protected within Canadian law. The balance of convenience favored KI because the judge found a public interest in encouraging the Crown to fulfill its duty to consult and accommodate Aboriginal peoples. Okay? Now this is another interesting interpretation by the judge because it's a contrast with this idea that economic development and public interest kind of automatically go together. Instead, it kind of puts forward the idea that having a consultation process that has integrity to it and is done properly is a matter of the public interest, even if it slows economic development. Okay? And to say that there's a public interest in the honor of the Crown in conducting consultation and accommodation properly does echo the Supreme Court interpretations of Section 35. Now, that was a great statement. However, a condition was placed on the injunction, which was that KI and Platinex should meet and discuss the implementation of a drilling plan. So while the injunction showed the importance of engaging in consultation before doing any work that could impact Aboriginal and treaty rights, this condition removed much of the meaningfulness from consultation because the goal was set out. The judge could not imagine that information might come to light that would show KI's Aboriginal and treaty rights could not actually be accommodated in this drilling program. So to the extent that consultation was fettered in its result, the recognition of KI's relationship with the land was compromised. Okay? Consultation, as ordered by Justice Smith, could not address the conflict because it assumes the rightfulness of Crown visions of land, and it undercuts the connection between Indigenous traditional attachments to the land and the manifestation of those attachments in the understandings of Aboriginal and treaty rights. Okay, so while the recognition of the attachment to land was really important and opened a door to an understanding of Kanawean Dundaki, it limited that recognition because of imposing that specific goal of drilling will go ahead. The next hearing was a hearing where Ontario applied to be taken in as intervener on the case in February of 2007, and they were granted intervener status. The next hearing was in April The next hearing was in May. On May 1st, 2007, the court lifted the injunction against Platinex and advised the parties to come to an agreement allowing the drilling to go ahead. In the consultation meetings that occurred, KI was concerned about the process of consultation. They wanted to work on their relationship with their treaty partner, Ontario. Ontario Platinex only wanted to talk about planning this specific drilling project in isolation from other issues. The judge found that the parties had consulted and decided that the memorandum of understanding that had been most recently proposed by Platinex showed enough accommodation of KI's Aboriginal and treaty rights for now. And as far as most exploration memorandum of understandings went at that time, it was actually pretty good, okay? For the most part, mining companies were ignoring First Nations communities and not doing any consulting and not making any efforts to make any kinds of agreements. However, this MOU was only worthwhile if KI was interested in mining, which they clearly were not. So what happened is the imposition of this consultation agreement closed that opening that was found in the earlier decision. The judge could no longer see the irreparable harm that was caused to KI's relationship with the land through the interference of mining. Following Ontario's argument, the issue in this case was narrowed to the scope of the duty to consult. That doesn't sound like affirmation or recognition of Aboriginal and treaty rights to me. Okay? They weren't dealing with a substance, but trying to figure out this scope of the duty to consult. The judge also lost his understanding of KI's relationship to the land as something that could be recognized and protected in Canadian law. He wrote, "The evidence of harm to the land, harvesting right, and KI community and culture was based upon assumptions and fear of what may transpire and is not causally connected to Platinex's proposed drilling program." So although the judge continued to acknowledge KI's perspective on their connection to the land and that they also had a perspective on the scope of the duty to consult, he was unable to connect that perspective to a recognizable legal right requiring protection. Okay, so in the first decision, Justice Smith also said that the Aboriginal perspective on the land was difficult for a non-Aboriginal person or legal system to understand, yet he tried to do so. In the second decision, when he reduced perspective to fears and assumptions, the judge simply stopped trying to understand. Okay, KI's perspective was there, but it became opaque and irrelevant to the judge. It was pushed out, okay, by the Canadian legal system. This meant that Ontario and Platinex no longer had to try to understand, rather they had to go through a process of consultation and accommodate something that was legally unrecognizable into the drilling program. The judge also made some obiter comments on Treaty 9. It wasn't before the judge, but what he said there is he focused on a very technical interpretation of the treaty, and he said that the community members misunderstood the treaty. Okay, he focused on the clause where it says the treaty is a surrender. This is not how the treaty was explained to the people of KI in 1929. This wasn't translated into OG Cree, and the perspectives on the treaty, Ontario's perspective and KI's perspective, are quite different. There's been a lot of Supreme Court cases that have also talked about interpretation of treaties, and that just reading the text out is no longer acceptable in terms of how you interpret treaties.